I want to talk a moment about people who move to Florida with powers of attorney or even other estate planning documents that were drafted and signed in other states. Now, generally speaking, and especially with the power of attorney, Florida will honor a power of attorney that was properly executed and is otherwise valid in the state in which it was executed. However, our recommendation still remains, if you move to Florida and you have capacity, you want to sign new Florida documents. And the reason is because even though the law says that Florida has to honor these out-of-state documents, what practically happens is when you have people who are not lawyers reviewing these documents, they don't always know what to do with it. They're used to seeing one type of document and it might look a lot differently. The other states have different signing requirements. So when people see a state that allows you to sign a power of attorney with one witness or with three witnesses, that doesn't necessarily match what they see with Florida, and it can be a barrier to getting things done. And so sometimes what I have to do when we don't have the abilities, right? Sometimes people do lose their capacity to sign new documents. If they come to me with an out-of-state power of attorney, I then have to go and get a letter from that out-of-state lawyer opining as to whether or not the document was legally drafted, whether it was legally executed, and not only that, whether or not it allows you to do this certain, specific and important activities, right? Some powers of attorney might be perfectly valid in other states for banking, but not valid for the more complicated strategies that we might need to employ, for example, as part of a Medicaid planning process. So even out-of-state powers of attorney, we have to get a lawyer to write a detailed letter saying not only was it validly executed, but you can do X, Y, and Z, which is going to kind of match whatever plan that you put together with my firm if we're doing Medicaid planning. So again, certainly in-state powers of attorney that were drafted by non-eligible or non-estate planning attorneys often need to be redone. Even a perfectly valid out-of-state power of attorney, even if it does give all these kind of all-encompassing powers, it still would be wise to get it done properly in Florida to avoid those roadblocks. Ultimately, we want to get things done, right? And anything that is an impediment, even if legally valid, if I have to go argue with a bank teller that why they should approve this out-of-state attorney, that's an impediment and a barrier to getting things done. So if you would avoid all that nonsense, would avoid all that delay by having a good, well-drafted Florida durable power of attorney. And if you're interested in Medicaid planning, you want it to be a Medicaid compliant durable power of attorney, which is different from other powers of attorney. So I hope you found this video useful. If you are out of state moving to Florida, you do have capacity. Very important to meet with an elder law attorney to get a good solid set of Florida based estate planning documents. Thank you for watching.